Welcome, everyone. Really excited to speak about ethics, and I've learned so much from our panelists by preparing this this panel, and getting to understand how different countries perceive the obligations, and what obligations rely on the arbitrators, what obligations rely on the parties, and what the local law says. So hopefully we can have a dynamic dialogue here. You should have at least one mic to share. Oh, here we go. Perfect. So basically we'll be doing this. To speak with us today, we have Patricia Nacimiento from Herbert Smith Freehills in Frankfurt. You lead, Patricia, the German dispute resolution team and the EMEA team for international arbitration at Herbert Smith.
Maybe you could say a few words of, ethical standards in arbitration in, your jurisdiction or different jurisdictions you've had experiences, and especially when it comes to conflict of interest and duty of disclosure and so on and so forth.
Yeah, so basically we.
Yeah, if you don't mind for the people that
yeah,
are
sure.
at a distance. Is it on? I'm sorry, it has to be up. If you don't mind,
It is.
It is.
It is. Basically, we go right into the center of arbitration, right? If we start discussing about disclosure, conflict of interest. This is where it's strictly connected to independence and impartiality, and that really is the cornerstone of arbitration. It only works if there is independence and impartiality, so this cannot be emphasized enough. And I would say it is well embedded by now in all rules, in all, not just the rules of the arbitral institutions, but also obviously we have the IPA guidelines. We have a number of new rules and new developments also, but everywhere you would see the same principle, and that is the principle of impartiality and independence, and that is strictly connected to disclosure, which means an arbitrator needs to voluntarily disclose anything that could appear from the perspective of a reasonable third party. That is an important criteria. It's a reasonable third party. That's the test here. It's not what you may think subjectively. It's not an objective standard, but reasonable and a third party, and if it could appear as such. So it is a high standard, and it means that for an arbitrator there is an ongoing duty to disclose, to be very frank about this, and I believe we will be touching upon this a bit later because things have changed and things have developed towards a very strict standard. And sometimes maybe it could be debated as to whether it's still the right standard, and maybe we are going a bit beyond or as to what is necessary. But I believe, Stéphane, we will be touching upon this a bit later.
Right. No, absolutely, and I note the reasonableness standard, which is a superb word that lawyers like to bend and twist and argue against repeatedly. Michael, would you like to say a few words on that issue?
Sure. Thanks. So obviously there's going to be a lot of overlap between our different jurisdictions, and we can come back later to to why that is and why it's so important. Looking to France in particular, I think we've seen over the last few years, or many years, the French courts really pushing to a high standard of disclosure. There's been more and more of an obligation on arbitrators to disclose any circumstances that might, in the eyes of the parties, and that's something that might distinguish with what Patricia just said, lead to a question about independence and impartiality. And there can be a big debate about whether the standard should be in the eyes of the parties or in the eyes of an objective third party or in the eyes of the parties acting reasonably. So this kind of subjective versus objective debate. I think one of the troubling things or difficult things that the French courts have struggled with is, while pushing forward this obligation of disclosure, they're also always saying that the fact that you disclose something doesn't mean that it's necessarily something that will cause you to be recused if a party doesn't accept it. So when you say, on the one hand, okay, our standard for independence and impartiality is that, let's just say, in the eyes of a reasonably viewed by the parties or a reasonable third-party observer, it doesn't create a problem. Then when you say, okay, you have to disclose something that might be viewed by the parties, but just because you disclose it doesn't mean it is, there's this tension between, do I have to disclose something that I don't actually think creates any problem of impartiality or independence, but maybe the parties will think it, but I think the parties would be wrong and it wouldn't be reasonable for them to think of it, and if I disclose it, is that kind of indicating there's a problem? But if I don't disclose it, then does it make it look like I'm hiding something? And so the French courts over the last few years have pushed arbitrators to say, disclose more, and certainly if you don't disclose and then something is found out later, then there's going to be some kind of issue. So that, as background, has been where we've been going for the last few years, and that's really pushed to a big, heavy disclosure obligation on arbitrators. I'd say the most recent things, and since we're on an annual conference, even though you don't do an update on ethics every year, Stéphane, in the last few months, we've seen some really interesting decisions coming out of the French Cour de Cassation and the Cour d'appel de Paris, the Paris Court of Appeals. So in November of last year, the Cour de Cassation issued a decision. It was 29th of November in the Bid Auto case, where it said that the party complaining and seeking an annulment of an award on the basis of a lack of independence and impartiality, in that case it approved a court of appeal that said that party had not proved that it could not have known about this problem in advance and had to raise it in advance. So, sorry, I skipped a step in this. Under Article 1466 of the French Code of Civil Procedure, if a party is aware of a problem in the course of an arbitration and doesn't raise it in a timely fashion without a legitimate excuse, then it's deemed to have waived the objection. So obviously in the case of arbitrator independence and impartiality, the last thing we want is for parties to find out something about an arbitrator that wasn't disclosed, stick it in their pocket as an insurance policy against a bad award, and then when they lose the award, come and say, I'm attacking this award because of this undisclosed aspect. So the French law says, as many do, you waive your right if you don't raise it. But then the question is, what does that mean if a party is aware of something but didn't raise it and didn't have a legitimate excuse for not raising it? And the French courts have said for some time, being aware of something also means should have been aware. And so what the French Cour de Cassation, now to get back to where I was, sorry, sleepless night in an airplane, in November what it said is the party in this case failed to prove that it could not have reasonably found this out. So it put the burden of proof on the party to say it needs to prove why it couldn't have found this out. And so what you'll see is other parties saying, oh, if you had done some internet research, if you had dug a little deeper, you would have found this out. And on the one hand, it puts a burden of due diligence on the parties and a heightened burden of due diligence on the parties, and is putting a burden of proof on the parties to show that they couldn't have found it out. And following that decision, although I expect these decisions were made before the Cour de Cassation decision was really public, because just the following month, the Cour d'appel de Paris in 2 cases said claims of a lack of independence or impartiality because of failure of disclosure were waived because a party should have known about the facts in advance and didn't. One of those involves the arbitrator and the in-house counsel, who's the party representative in an arbitration, both sitting on not the ICC Court of Arbitration, but on the French National Committee, Arbitration Committee. The ICC France's Arbitration Committee. And they said, oh, but the Arbitration Committee works together in picking potential nominations of arbitrators. These people worked together on that. They also did a webinar together, and they raised that seeking to annul the case. And what the court said is, you know, if you had looked at the ICC's website and ICC France's website, you would have seen their two names together. It was notorious, it was known, so you can't raise it now. And then in another case, the complaint was that the arbitrator had not disclosed the fact that he was subject to a complaint about corruption in a prior case. A very, very high-profile case with a high-profile arbitrator. We don't need to go into the question about that case, but the question was, should the arbitrator have disclosed that? And there again, the court said, well, it accepted the other side's position that GAR News had published about that case several times, and so you should have been aware of it. So it becomes a question of, okay, I mean, if you're GAR, you should be really happy, right? You've got the Paris Court of Appeals saying, read GAR, you know, make sure you know what's going on. But it could be subject to some debate. Okay, do we like this move? Do we think that's a good idea? Or if you're a party, you might be really surprised. If you're a counsel in international arbitration, it's definitely a warning signal saying, hey, you've got to really not just, you know, do a quick internet search, but you better really dive down kind of deep if you want to avoid that kind of complaint.
Merci, Michael. Eduardo, do you want to give us your take on this?
I think you all understood by now that, I mean, the duty to disclosure, independence and impartiality, those are traditional topics, classic topics, right? They've been around for years, I think, since arbitration has been around. But from what you just heard from Patricia and Michael, you've seen that there is this tension because the standard under Brazilian law is the same. You know, facts and circumstances that raise justifiable doubts, and then in the eyes of the parties, in the eyes of a reasonable third party, but even those senses of reasonable third parties, eyes of the parties, who define them? Which parties? You have companies that are common users of arbitration. You have others that are, you know, are one-time users. And why this causes a tension, right? Why this tension that you heard from Michael that is coming out of the decisions here in France between, you know, the responsibility that lays certainly mostly with the arbitrators to disclose, but also a look that a party has as well to do some kind of, has to be also partially responsible. Are the obligations and the responsibilities the same? It doesn't seem so. And probably that's not also the view of the Cour de Cassation. But why is this all coming up? Because, as Patricia said, it's such a cornerstone of international arbitration, independence, of impartiality, that it's not become uncommon that parties that are frustrated with the outcome of an award, when they have to think about where are we going to change this decision. I don't have an appeal. What can I do? Well, I try to vacate this award. Guess what? What's the best way to vacate an award? Is to use this concept that is not well established. You don't have a very strong criteria. You have the IBA guidelines, but are the IBA guidelines really to follow blindly? Of course not. You have the ICC that has their own aspects and approach to independence of impartiality, and you have national courts that not always have been so used and has, you know, have not made, maybe in Germany they have established a standard that now it's common sense. But certainly it's not the case in Brazil. So we have witnessed in Brazil, and it gets more complicated in Brazil, because if you look what happened in the past years, Brazil went from 20 years ago being a nobody in the world of international arbitration. There was no arbitrations almost in Brazil, to become one of the main players of arbitration, you know, worldwide. You know, in the ICC statistics, Brazil is number 2, number 3, has always been now in the past 5-6 years on the top 3. But this sudden growth, you know, people talk about the pains of a quick growth are happening there. So judges are looking at that, and they're not totally understanding. So one first thing that we saw, as Michael was talking about, I think, you know, what's established worldwide is that the lack of disclosure per se is not a reason for disqualification of the arbitration and for setting aside award. But we see a few decisions in Brazil where it has been an automatic conclusion. Oh, there is a lack of disclosure, so the award should be set aside. Sort of, what is this animal arbitration? You know, they try to do our job. So when you look at courts, there's still a lot to develop in terms of you know, awareness of, and you see even here in a well-established market, this goes back and forth. But I think honestly, the main risk that we have, and I think the main point is that I think everybody here, I would imagine that we will all agree that, you know, the rule for the arbitrator should be disclose, disclose, and disclose. I think there's no doubt about it. The problem is how you deal with that party that, you know, keeps in their pocket, you know, an information so they can have, as Michael said, an insurance or a hedge at the end, and how you address that in court. So I think this duty of curiosity or duty to get informed by the parties seems to be, and of course, it doesn't land at first at the best place, and probably I think, you know, here there may be doubts if GAR is the main place for you to get informed and how parties should get informed, because there shouldn't be, I think, a shift to the parties of an obligation that remains mostly with the arbitrators, but certainly it's not arbitrator-only responsibility, exactly in order to avoid this abusive use of problems, you know, or of attacks to independence of impartiality that only aim at and trying to just void an award.
Thank you, Eduardo. Well, how about India?
I mean, I've heard everyone, and I think I might have a slightly different view on what happens in India. I think it starts from the fact that the standard of disclosure under Indian law is codified. So the Arbitration Act itself has a full page of what the disclosure requirements are. And I don't think that was the case a few years ago when the amendment was brought in. I think what India did was learnt from the global issue, learned from global problems on independence and problems faced by parties in terms of whether there was impartiality or partiality in arbitration. So a lot of time was spent by the legislature on realizing what's the global standard, how should India tackle with it, given the fact that, as Eduardo said, I think the same case with India, 20 years ago, India was not on the map of arbitration.
Our
and
legislations are from the same year,
yeah.
1996.
And now, and Brazil may have the data from ICC, but if you look at India, it's more connected to the Singapore Arbitration Center, and maximum cases come from there. But having said that, I think once the amendments were made and once the law was codified, what it did was a very interesting thing, is they brought in this disclosure requirement upfront, so it couldn't be a ground for challenge later. In the earlier regime prior to the amendment, this was misused. Of course, people who were not satisfied with the award would make all kinds of allegations. But given the amendment, and given the fact that the act was codified in such a fashion that it just stopped you from making that, take that ground at a challenge of award stage. And it told you, the act very clearly said that if you feel in a reasonable assumption that there could be impartiality, then you have to bring it at the first instance. And if you don't, then we are not going to entertain it. But having said that, there are cases, there are circumstances where things were discovered later or through the process. And let me share a very interesting story. I don't know if you ever encountered that, but India has a lot of ad hoc and institutional arbitration. So aside from a lot of ICC, SIAC, LCIA arbitration, there are ad hoc arbitrations between parties where parties have arbitration clauses and they don't have an institution which helps them. And in one of the ad hoc arbitrations where I was representing one of the client, the counterparty filed a application in the court saying that this arbitration is not fair. And the ground that they used was, since the arbitration was in a particular city in India, the counterparty's arbitrator was traveling in the same car with other arbitrator. And that became a ground for challenge. And if it was pre-amendment regime in India, I can tell you that it could have gone on for 3-4 years till that would have finally attained some kind of closure at court. But when this was brought to court, the court simply said that if you in your reasonable wisdom feel that this is impartiality, then the test has to be seen from the eyes of the law and the precedents in the country. Unless you can bring me some material to say that that was the reason you lost the arbitration, we are not going to set it aside. So the regime has become, what I'm trying to say is the regime has become a little strict. Disclosure requirements have become lengthy. I think in India, traditionally, arbitrations, the arbitrators who would sit as arbitrators in sort of all institutional arbitrations would be retired judges, because the judges retire at a certain age in India, and then people feel that they're the best adjudicators of disputes. So they would have seen a career of being in judiciary and being an institution themselves. So the trust factor would naturally come there. I think what has happened in the last 10-15 years is that there are more professional arbitrators in India who are doing this for a living, and now not a Saturday game for them that I'm going to just sit as an arbitrator to just earn some money. But I think people are taking it seriously and as a mode of profession, which then, given just the size of the market and I think the chance that they have to make a name globally, I have not seen too many cases in India where, arbitrators have been charged of impartiality or being unfair. And it's very surprising because given the size of the country, you will feel that, it can have all kinds of cases. But India surprisingly does not have too many cases which involve impartiality of arbitrators as a ground to challenge.
Please do.
Yeah, I would just like to comment on something. Since we're here in ICC land, I would like to really raise something which it's my observation. I cannot say that this is tested or anything, but my observation is that the ICC has become very strict, and you said disclosure, yes, but the reality is that if there are disclosures, then the tendency is that arbitrators will not be confirmed. And there's one area now where it is really difficult to find arbitrators, and that is in disputes where Russia as a state or Russian governed or owned parties are a party. And I would say right now the world already has divided, and there is a division between arbitrators being appointed by either Russia or Russian-related entities, and others who will not take such appointments. And I'm not making any assessment. But I believe this is a true observation. And the question is, or really the difficulty is then finding arbitrators. And there has been now this Russia, and it's really quote-unquote unfriendly countries. And so the tendency of the ICC is, in case there is a default appointment, which is often the case in these cases, then they go to countries like India, like Latin America, and you suddenly see a new group of arbitrators coming up. And this is something that we need to look at very carefully, because in all of these disputes, finding an arbitrator has become really, really, really difficult. And I think I completely agree with duty of disclosure and the strict standard. But on the other hand, it needs to be also practical, and there needs to be some reasonable standard in all of this.
No, thank you so much, Eduardo. I see you
just-
maybe
yes,
want to
just-
react.
We're going to jointly speak
Yes.
for the ICC.
Can we sing? No, but tell me if you agree. I think the issue with the Russian and Russian-related entities is really, I think, a difficult issue. It's true that us in Latin America were a bit further from, of course, the sanctions world and all that. And we've seen a lot of colleagues that now are thought for cases that are completely unrelated to Latin America. But just going to, and I'm not sure what's happening within the ICC. That doesn't go so much through the vice president. It's a lot that is taken by the Secretary General in the Secretariat. But it's true that I think disclosures would result in non-appointments, mostly when you had direct appointments by the court, rather than an appointment by parties. And it's true that I think in the past used to be, if you had any qualified statement of independence, in these cases, you would not be chosen because they would look for somebody else who has a completely clean slate in terms of, but I think this has changed now, because you had still have that list of related entities that is very vast, and it's almost impossible that you don't have some kind of relation. But I think due to the difficulties, not only I think in the Russian-related cases, but in general, I think the court takes a more, I'd say, flexible approach. I don't know if you agree.
No, overall, of course, I agree. I think it was definitely pre-Russian cases. It's been at least 5-6 years, I think, that the ICC has moved away from the we're just not going to consider if you disclose, precisely because they were concerned about putting a brake on disclosure. But that said, when you're in a court session and you have to decide amongst 3 possible candidates, and the court members then often do look at it and say, okay, which of these do we want? It plays into your mind if there's a disclosure. But I also think that the court's sophisticated enough now to say, okay, that's the kind of disclosure that they're just being very cautious on, and it's not going to create a problem. If a party wants to object, they will. So it's better than it was, but I'm sure you're correct that people are afraid of it.
I don't want to be too ICC centric, but
And don't invite two vice presidents.
and they're bound to disagree, right? But maybe we can sort of go to the IBA and its sort of updated guidelines on conflict of interest in international arbitration. Maybe Eduardo, you want to say a few words, and we can just continue the conversation.
Sure. I can just kick off. I think there's a number. It's the second review of the IBA guidelines of conflict of interest. I think, without any doubt, it has become like the most popular product of the IBA Arbitration Committee over the years. It's debated everywhere, and so it's first from 2004. It was revised into 2014, and once again now, just a few weeks ago, the IBA Arbitration Committee released the new IBA guidelines. It has not been profoundly changed, but it has introduced, like amendments and some points of redaction that make a difference. And I'll just mention a few, and there will be, I think, others that will comment on other points. I think one of them is, I think, a clear specification that lack of disclosure does not result in a conflict of interest, and certainly does not disqualify the arbitrator, but includes also in the disclosure this concept of a duty for the arbitrators to do some kind of investigation, which I think it's something that has already been discussed in the international practice. Some arbitrators say, oh, I threw away all my files. I've seen that in a concrete case. I threw away all my files, so I don't have anything from 2 years ago or 3 years ago, which was, oh, listen. But go do some kind of, try to find some information. So I think there are some information that an arbitrator can find. Another thing goes to a point that I think is exactly the one that Michael brought about the decision of the Cour d'appel de Paris, or it was the Cour de Cassation? No, the duty to inform, duty of the parties as well to investigate. So there is an inclusion of a degree of duty of the parties to inform themselves on a reasonable basis. Again, it does not shift the responsibility from the arbitrators to the parties, but it includes to the parties that there are information that they own, and that, of course, we always think about, related entities. There are things that, a party may know better or may be clearer to the parties than it will be to the arbitrators. Then there are like changes in language, for instance. The rules always mention the arbitrator's law firm when considering conflicts, and now it says the arbitrator's employer, because it's aiming also at non-lawyers arbitrators. And also something that I think it's very interesting for the insurers, maybe not that interesting, but it affects the insurers and the third-party funders, which is the concept that if the insurer or the third-party funder has a controlling influence over the case, it has to be compared to a party. It should be considered a party for all standards of the rules. There is also, I think, an interesting thing that it's been discussed all over, right? There is in the orange list, I don't recall exactly the point, but there is a reference to appearances and of the arbitrator in social media, and how social media can, of course, influence points about again, the conflicts of interest. But I'm certain that others have other views and other points, but the changes were not really profound.
Thank you, Eduardo. There's case law in France on social media, and a Facebook friend is not a friend for purposes of conflict of interest. So I'm sorry about all these, amazing friends you thought you had, but yeah. Ashish, do you want to say a few words or highlight a few specific items?
So I think the basis on which the amendment in the Indian arbitration happened was the IBA guidelines of 2014, and I think globally, I'm glad to know that there's a relook at things after a gap of 10-15 years, because it becomes important. I think India itself was infamous for not having a very steady arbitration regime, and it kept changing due to conflicting judgments. But I think once a robust change was made to the Arbitration Act, that really kicked off a new generation for arbitration lawyers, and I think it brought India onto the map. So frankly, the new arbitration guidelines that the IB has released, I'm sort of glad to inform that India already has some of them in the codified act, which has really led to, as I was saying earlier, that ethics and impartiality is not a major ground in India in terms of how arbitrations are challenged. I think one of the reasons there is, and it's a very interesting observation, I don't know whether it exists in any of your jurisdictions, but given what I was saying earlier, that majority of arbitrators in India are people who have been in the judiciary, and the general sort of, it's not a rule, but the practice of anybody becoming a judge in India, the day they get appointed, their life becomes reclusive. They have no social life. I can't remember the last time I saw a sitting judge, even sharing a drink with a counsel somewhere. So that's the kind of reclusive life they lead in India. When
you should teach the Brazilian judges that for sure.
And sometimes it's very difficult, and sometimes people like us who are lawyers want to invite them for something like this, and they'll plainly refuse, saying that we can't be aligned to a single firm. And that's the kind of reclusive life they live. So once they come into arbitration, some of the guys who are disciplined continue to live like that. Some of the guys who are not, then they go crazy. So the point being that, we as lawyers and parties, when we advise, we know the set of guys who will be safe in terms of ethics, impartiality. I think the larger problem sometimes in India is there existence of corruption in arbitration? And frankly, if I would look at statistics again in India, I don't think these allegations exist in sort of corridor whispers, but I don't think anybody has taken those positions to court and said, some arbitrator was bribed, for example. So, those are corridor gossips that we hear, but like I said earlier, given the fact that the background from which majority of arbitrators come in India, I think the parties feel very comfortable around the fact that they would be pretty impartial in that sense, and given the robust disclosure requirements now, I think, as we were talking earlier, so many times when a disclosure comes to us as counsels, we just write to them saying, sorry, we can't appoint you, or we write it to the institution, because the disclosure requirements are so robust that if you do a simple Google search, you'll be able to find it. So, as I said, there are some silly sort of issues that arise in terms of bias, etc. And that's probably because of the size of the country, and you're looking at 1 billion people, right? And I don't know, 100,000 cases a year. But if I look at, averaging out, I think this is an issue which somehow seems to have come under more control since the amendments and the corresponding judicial interventions on this issue.
Thanks so much. Yes, please do, Patricia. Go ahead.
To follow up also on what I just heard, I mean, two issues that I would like to touch upon. One is you mentioned the duties of the arbitrators, and I think, and I want to make a counter-example that I lived and I was really shocked. For me, not just for me, I think it's a principle that if you do a conflict check, you run the conflict check fully. That is, you're not limited to the party, but also to all the subsidiaries. And in a recent case, ICC, one of the arbitrators, or actually the chairperson, did not do this. And he said so openly, but only after the fact, because he had joined the law firm that was representing the subsidiary. And a challenge was not successful. And I think this is wrong. Actually, he should have run a full conflict check first. I think that in itself should have been sufficient to disqualify him. Second, the moment he says so, the ICC should have reacted. So this is where I see sometimes in practice some discrepancy. And the other point I wanted to touch upon is arbitration is very much a community. And obviously you have 1 billion people, but there will still be a community. And I think it's the same for you. And just look at this room, there is a community. So I think as an arbitrator, but also as a counsel, you need to exercise some common sense when you meet, because obviously you will not avoid meeting. But I think it is important how you do this, and it's very important, I would say, both for counsel and arbitrator. I mean, just to, you can greet each other, but that's it. You're not going to the bar, and you're not going and have a meal and so on. I think this is absolutely inappropriate, but I still see it happening, and it makes me furious. And when I see, opposing counsel sitting and having dinner during one of these conferences with one of the arbitrators, that's completely inappropriate. And I think this is where there needs to be a development of some self-control and actually some awareness of what is right and what is wrong, because obviously this is not something that you could put down in strong and in solid rules. This is just, it's common sense.
I know you have a second point, Patricia, but I see
No,
Michael.
that was my second
Oh, okay. I see Michael nodding, but I like the idea that, in effect, by behaving inappropriately, you're actually hurting the entire community and arbitration itself. Yes. Michael.
So in my foggy, jet-lagged brain, let me try and tie a couple of things together, because the IBA rules, coming back to that part of your question, are extremely important because for many reasons, but one is to try and create some kind of global standard. And I'm glad to see, for example, the French courts citing the IBA rules. There's some question at the ICC whether, we don't adopt the IBA rules, but we take them into consideration. The important thing, though, is when you have an international arbitration award, and it could be enforced potentially anywhere in the world, and a lack of impartiality and independence could be a ground for refusal of enforcement. If you have different standards around the world, an award could survive annulment in one place because in that country it's not deemed a problem, but then be refused enforcement in another country because that country has a stricter standard. The IBA guidelines play a really important role. But then if we look at some of the elements in the guidelines in light of some of the things that were just said, so for example, in India, this idea like you won't even see, you certainly won't have a meal with or do anything with an arbitrator in your case. That, I think, historically in France, people would say, what are you kidding? Yes, we're not a billion people with a small arbitration community. Paris is the home of international arbitration. We have a very tight-knit arbitration community. A lot of people sit as arbitrators in council. I mean, and in France, I'm sorry, in Paris, you can't not have lunch with people. So, are you seriously saying I can't speak to this person for 3 years while they're sitting in a case? And it's very, very contentious, and it's become more contentious in recent years because of the old school thing of, oh, we all trust each other and everyone goes along. The world has shifted. But I do think that in Paris, we have trouble with that. So I was recently at a conference and a conference lunch where opposing counsel was sitting at a table with the chair of the tribunal, and at my table, one of the other arbitrators was there and moved to a different table. And then, but we were joking that, well, there was somebody else from opposing counsel was at the table with me. So, but it was a very, we had a debate for half an hour over lunch about what the standard is and whether it's okay to be at a professional conference lunch with one of the arbitrators in a case.
That's actually great that you actually had that conversation, right?
It was a very, very interesting conversation. And I have had arbitrators turn their back when they see me across the room at an IBA conference with 1,000 people in the room. Say, oh, can't be seen together. You never know what could happen. Someone could take a picture and we could be in trouble. So coming back to the IBA rules, I'm not sure that the IBA rules currently really address this as well as they could. A close personal friendship is an orange list item on the IBA rules, and that's a close personal friendship, right? So how do you define what that is? And that, I think, is going to be one of the tough areas, because different kinds of professional contacts, other contacts that you might see available on public, on the web are one thing, but how, and that's something that as a council, when arbitration tribunals are being constituted, I think we all struggle with. Say, oh, so-and-so named so-and-so. And then you start to have to say, like, how do I have to now start going through my friends of their friends and trying to find out, how close are those two people, and is there going to be disclosure? So I think we could still make progress on that, especially if when you hear voices from around the world saying, it should be really far, and then in other places saying, come on, we trust each other. Trying to get to an international standard on that, I think, is going to be very, very difficult.
Yeah, go ahead, Ashish.
I think one point which is essential is also the fact that it's very subjective in that sense. How do you control it? And as I was saying earlier, that till the time judges who sit on the bench in India, they're different people, and once they retire, they're different people. So the fact is that some of them who want to be seriously considered as future arbitrators after they retire, they want to conduct themselves in a particular fashion. I think one of the things very interesting in India is that if you've retired as a Supreme Court judge, you're not allowed to practice in the Supreme Court thereafter ever in your life. That's the level of sort of conflict issues that the judiciary as a large looks at. But having said that, I mean, the problems that you're saying, that can I be seen dining with an arbitrator in an ongoing case? There's no restriction under Indian law. Do people do it? Yes, they do it. Do all of them do it? No. Some of them who understand international arbitration more closely, they find it strange to do it. But as I said, there's lots of ad hoc arbitrations in India. So people who don't know global standards, for them it's routine to have a meal with an arbitrator if they meet socially. But people who are looking at international arbitrations, for them they're tuned to an IBA way of doing things and look at the guidelines more quickly, more carefully. And then they restrict themselves in meeting them. So look, I think India's model, when you look at impartiality and fairness, it should be looked at from how the judiciary behaves. I think we are at that cusp where, you know, as I said, there are people getting into more professional arbitrators who are not judges. I think the next 5 to 7 years would be really important. And I consider myself a part of it, that how we behave who are not from the bench, who've not led a reclusive life, how do we deal with sitting as arbitrators, and what standards do we put in? I think that's something that introspection of people around the world is something that everyone needs to see, because it's very subjective.
Yeah, thanks so much. I love this reaction. They're making my job so easy, you know, as a moderator. It's just a wonderful conversation I can listen to. I do want to add, you know, a couple of points I'd love to hear all four of you on, and you know, but please do continue. This is just wonderful. You know, as a very practical matter, you know, what have you seen arbitrators do that made, you know, you and your clients feel more comfortable in terms of process, right? Because then, you know, how close is a friend, how, you know, and those are standards, the reasonableness standards, and so on and so forth. But, you know, what tips do you have, and what concerns with respect to what lies ahead? And then please do react. I think I had Eduardo and Patricia, and then, but try and include maybe some practical advice, if any.
Right. Just, and not dodging your question, but I mean, why are we discussing that, right? I think why is that so important? It's because we tend, and Patricia, I think, addressed this very well. I think there is this sense of a community, but the community is a community of counsel, of arbitrators, of people who are always in that. But we forget sometimes that the end user, which is the companies, they're not. They don't consider themselves, and to be honest, they don't want to be a part of the community. They are there. There is a service that is being offered, that they can have something that is efficient, that is neutral, that they will not have the bias that some national courts may have. And so I think they are offered something, and they are, I think, are entitled to what they are being offered. So I think that's what we have to bear in mind, you know. Maybe, I mean, Patricia has a very, I think, strict view on that. They should not have lunch. Maybe I have a different view. But there is the thing that when you think about the end user, for them it's very hard to understand. It's very hard to understand that Patricia had dinner with me, and then she rendered the award in the favor of my client, and then, you know, Stéphane's client wasn't there, lost, and Stéphane wasn't close to Patricia. So we have to perceive. Of course, if people want to do wrong things, and that's worth for anything in life, they can do it without any appearance. But I think that, and I know probably it's totally politically incorrect, this example of, we used to say, of Caesar's wife, but it's still, I'd say, valid just for the phrase, you know. It's not enough to be honest, you have to appear honest, and I think that the users demand that, you know, and we should not take this lightly. In terms of really practical things that I saw, I cannot think of anything other than actually what I said before. I think, you know, and the ICC pushes for it. I think everybody should push for it. You know, you see some arbitrators that they want to, you know, they feel like, oh, but should I disclose everything? And then they hide behind the thing that, oh, but if I disclose everything, then, I mean, we have no limits on disclosure. But honestly, I mean, even more at the outset of the case, you should. I mean, you should really put it all on the table. It's easy. If the case has not started, and if you are not the correct arbitrator, another one can be chosen. So I think that, you know, maybe all the issues that we are witnessing worldwide in relation to challenges, and even the abusive challenges and the use of so-called lack of independence, of impartiality, just to change the outcome of an award, has this positive, probably collateral effect, that making people understand that they are responsible, that it's better. Because if they put it out there, everything at the beginning, and of course continue with the ongoing obligation, it's rare that, or it's going to be harder that a problem will appear. But that's why it has to come with some kind of objective standard, because otherwise there is no limit. Each party can, that's why I honestly think that the concept of eye of the parties throughout the whole time, it doesn't make any sense, because, each party may have, a different view. Say, oh, but I don't feel comfortable in that situation. That cannot be the standard. But that's, I didn't add much. Patricia will probably say something more interesting, but push for disclosure and for counsel to ask the arbitrator to really be completely transparent. I think it's very important.
Just because of people online.
Thank you. Good afternoon, everyone. I'm Thibaut Bouchala, working with KPMG Forensic, and my team acts mostly as a financial expert in commercial investment arbitration. And my question is as follows. Within your law firms, especially the global one, do you see coming the implementation of, I would say, formalized safeguards, like code of ethics, like formalized policies around conflict of interest, about do's and don'ts with counsels, with clients, or other arbitrators? Is that something that you see coming, like we saw it coming within, I would say, private corporations? Is that something that exists?
That's an interesting question, and I have to say I do not see this within law firms, but definitely it is something to be considered, and because a law firm obviously plays a role, and the global law firm even more so, because this is where you touch upon the main issue that there might be different standards. And so it actually would be a good idea to say, well, we as a law firm, this is how we do it, and to give some guidelines. I like this idea very much, and actually it leads to what I was going to say, that what we're talking about is not so much about hard rules, but it's more about the culture, and it's the culture of a community, right? And you become aware of this, and you become part of this. And I can say in Europe for a long time, or when I started out, this was an old boys club, and I can say this very comfortably because I wasn't part of it, obviously. But this is also how people acted, and I think this needed to change, and it has changed. And I think what made it change, and for example, if I look at Germany, what made it change is that when the German arbitration community became more exposed to the international arbitration community. And I think this is also how you create the culture, because then you have sort of a certain standard, and then you agree on a certain standard. And I think it has a lot to do with self-restraint in the end, because you cannot really have hard rules. But we should also not forget why it is so important, because the whole system stands and falls with integrity. And we should not forget these are private parties, private people. And so they're not really in a framework. They are private, and this is why we have to have some limit, and it needs to be a self-imposed limit. But unless, and this is why, I think you mentioned it in the beginning, it's an old topic. Yeah, maybe it's an old topic, but, it's every day an important topic, because if we don't have this, then arbitration will die. And just think about all the criticism. Think about also, I liked your point about looking at the arbitration community through the eyes of a client, because there's a lot of things that they just don't understand, and it's very difficult to to explain it to them. And then you think for yourself, well, actually, you're right. This is strange. And then if you look at investment arbitration, even more so, and it's this kind of distrust that has changed the system, that has affected the system, and in particular in Europe, look where it has left us in relation to intra-EU BIT. So it started small with some distrust, but it ended big. And the same can happen to commercial arbitration.
That it's old, but it's classic.
That's
Because it's so
maybe you
throughout
can
the-
exactly. It's classic. Maybe that's the.
I'm grateful, Patricia, that you are such a defensor of the choice of issue for our panel today. That ethics is important, and I adore your faith in mankind or humanity. That you think that each individual can find it in him, herself, to deal with that. Super. Yeah.
Sorry, trying to respond, although I should probably avoid trying to respond to your question about whether we would put in place internal guidelines and all. And it's nice to hear that coming from KPMG, where I think you probably have a pile of internal guidelines about a lot of things. And so, for example, one of my roles, which I absolutely adore at DLA Piper, is that I have to approve any arbitral appointment by anybody in the firm, at least on this side of the Atlantic and the other side of the Pacific. Somebody in the Americas deals with the Americas appointments, and so we do have a policy. Which, when people seem to be a little confused about what they can take or what they have to disclose, I, at least get to throw a policy at their way and say, if you don't like what I'm telling you, talk to the managing partner, and so it helps to have a policy like that. And we do try to, through that policy, try and get the highest common denominator, at least in terms of disclosure and all at the beginning. Now, trying to put in a firm-wide policy for how to behave and ethics throughout the course of an arbitration, when there are lots of guidelines out there already, I think is more complicated. Maybe a firm would be afraid to do it because fear of creating more liability for the firm if something goes wrong. On the other hand, maybe the firms already have liability, especially if it's a partner who's sitting. So I don't think I see us going so far as doing that, but what we certainly do is have internal trainings, and so we try and keep a culture of understanding of where it's going. Coming back just briefly to your question about practical points, one thing I'd say is, if it really became the generally accepted principle that you don't have, say, lunch or dinner, a meal with an arbitrator in a case, and I certainly follow that rule myself, I think people would tend not to appoint their friends in cases so much, right? I mean, I had someone who I was friendly with, right? I'd consider her, a friend, not a close friend. I appointed her in a case, and then for the next 3.5 years, did not see her, right? And so when the case was over, it was finally like, oh, maybe we could go and have a drink someday. And so if you follow that rule, and if people follow that rule generally, they're not going to want to appoint their friends because, it depends on how important your friendship is. And it is important also from an appearance perspective, and you're absolutely right. So, I mean, it's notorious among some parts of the community, and certainly to all the students in the arbitration class I teach, that one of our mutual friends, Bart Legum, and I are very good friends. We go bicycle riding almost every week together, okay? So I'd say to my students in my class, can I appoint Bart in a case? Can he appoint me? And I kind of laugh actually when we say we don't really talk very much, because usually if it's an uphill, he's way ahead of me, and I'm just panting behind him. And if it's a downhill, I'm way in front of him because I weigh more. But seriously, no. From an appearance of impropriety, no way we can be in cases together. But in reality, the reason we wouldn't want to do that is not because there would be bias, but because he would have no problem ruling against me, and I would have no problem ruling against him. So it's probably more our friendship that would be in danger than the integrity of the arbitration procedure. But I do think that just a practical rule of no, don't have meals with an arbitrator, unless it's in a professional context with a lot of other people, would also be a healthy kind of global rule that would prevent people from. It would really put a limit on how close people are with people they're appointing.
I think you briefly mentioned about social media posts and their impact on conflict. That's a topic we haven't sort of heard of much in Asia. And it would be good to hear what are the basic do's and don'ts, whether as counsel or for those of us who sit as arbitrators, as to what that is and what the law is developing on that in France.
Who wants to pick up on? The two vice presidents are conferring on determining the answer.
No, we are just looking because there are two references, I think, in the new IBA guidelines. For instance, one, it's a green list if the arbitrator is friends with one of the parties and probably counsel on social media that would not. So, I mean, if you think about green list, it should not need necessarily be disclosed. But on the orange list is if you have to be careful on your publications, or you should inform in case, I think you publish, you give opinions, right, or advocate or publish a paper about a topic that can be related to the case, right?
About the case.
Yeah, about the case. So the arbitrator has publicly advocated a position on the case, whether in a published paper or speech through social media or online professional network. So that's an orange list. So that's, I think, how the IBA guidelines landed on that. But certainly there is much more in between, right? I think there are all kinds of activities, and I mean, the more you go, I think that most of the arbitrators these days prefer to stay out of social media, and many lawyers as well, because of some of the positions you may take. But certainly, and there have been some cases of challenges, right? You want to say something?
No, okay, merci. Maybe Ashish, you want to weigh in and maybe a final comment each, and we'll.
So I think we were discussing, the way forward, what more can be done. I think one of the things, and I can take an example of India from there and how we sort of developed the arbitration regime is, we need to make the community larger. I think it also helps if you have an unknown person sitting with you on the panel. You're more concerned about your reputation as opposed to if you're sitting with friends. So I think, in India, a lot of times, if you have international arbitrations and the government is a counterparty, they look to appoint sometimes friendly arbitrators. But, when the ICC appoints the presiding, they'll have a neutral person outside of India who will have no clue about what the issue was. I think the exercise of making the community bigger and not having regional communities, so to say, that if it's an India arbitration, let only 3 Indians sit on a panel. I think it's more human in that sense, because if I'm sitting on a panel with somebody I don't know well, the chances of me making sure that I have an impeccable, absolutely impeccable image in terms of how I conduct myself will always be a factor which can be weighed in. I think India sees that quite a lot now. If you look at all Indian arbitration institutions, majority of members, amongst the fact that there are a few Indians there are a lot of people who are not Indians there. And a lot of Indian big ticket arbitrations, you'll find foreign arbitrators there. And I think one of the reasons, even as counsel, sometimes when we advise our clients, would automatically say that, I would believe that somebody who's made a name globally would always, from a counsel's perspective, when we are advising clients, say, oh, I think he has a great reputation, right? And that reputation is based on the fact that what he's done or she's done. I think the larger we make the community, and as Patricia was saying, that we are a community, right? And we need to make sure that we protect and also ensure that we promote people from various regions into the international sphere. And I can say this, the Indian arbitration community and the Indian arbitration regime has improved only by looking at the good things about the global standards, right? I think now it's time where the rest of the world looks at how we adopted those good things and how perhaps some things can be learned from how arbitrators behave in India.
Thank you so much. Patricia, say a final word?
Yeah, maybe just to follow up on this, and I think it is about diversity, and diversity is not necessarily linked to your background or anything, but for me it's a diversity of thinking, it's a diversity of minds. And arbitration clearly is an international arbitration clearly is a diverse area, and we need to strive to make it as diverse as possible. And also thinking about, well, what is actually the international in international arbitration? It's not a place, it's a mindset. And this is, if we go towards an international mindset, we will find rules and principles on which we agree, because in the end, I mean, this is probably the one area where lawyers around the world engage under more or less the same principles. And the more we do this and the more we become truly international, the more we will have some unified rules.
Following the order and leaving Michael for famous last words. Now, I fully agree that this is one, I think, specific, very important point. I think diversity and enlarging this community, I think they come hand in hand, right? But, you know, Brazil is a funny country, right? Because it's the only country in the Americas when we became independent from Portugal, we became a monarchy. All others became, we became a monarchy. And there was a dual party regime, right? So there were the liberals and the conservative. And there used to be the saying that nothing more conservative than a liberal in power and nothing more liberal than a conservative in the opposition. And I think I'm making this comparison just to say that one of the points that I think we can do is to remind us that most of us here have multiple hats. And that asking something that is very hard to ask from humanity in general, which is consistency and coherency, is something that is very important. So we have to walk the talk when we are appointed as arbitrators and think about all of those things that we discuss and really push for avoiding this appearance of bias by having improper relations. We have to disclose in order to safeguard the system. But also, when we are with our other hat of lawyers, we also have to have the courage to push back on our clients sometimes. Because sometimes we get too flexible and we can push the system to the limits, doing things that honestly are only aiming at getting a client in a position that is completely against what we all advocate and what we all say. So I think being able to say no in certain circumstances is also an ethical obligation that we have in order to be consistent and coherent with all the different hats that we have, and is probably a cornerstone for being in a position to ask for arbitrators and people and institutions to keep an ethical position in all dimensions. And actually, in my view, we are all here responsible in order to make this possible. Because if we get out of here, each of us, and because a client or anybody pushes us in a situation, then I think we are not doing what we have to do to make this community appear what it is, which is, a support for arbitration as the best method of dispute resolution ever invented. I always like to say that, the Churchill phrase about democracy is good for arbitration as well, saying the opposite, right? It's the worst method of dispute resolution, except for all others that have been invented. So I think we have to keep in mind that our obligation doesn't change and our commitments don't change when we change our heads.
I'm struggling with what Eduardo Damião just said, because on the one hand I obviously agree, very heartily with that. On the other hand, it is difficult when we have multiple hats and there's a system that we're all trying to improve, and then when you're advocating for a client, sometimes you have to take positions, as long as they're within the ethical limits of what you can do. You have to take positions, and sometimes you push those opinions, and sometimes those positions then actually help move the law or adjust law. So it's always a balancing act between these different hats. But obviously, of course, if a client is pushing you to do something which crosses lines and is going to create systemic problems, we have to have the courage to stand up or to walk away from a relationship. Another final point that I want to make is this topic, it's a little bit easy for us to, kind of talk about the global standards and these ethic rules and all, and talk about the importance, and I raised it myself, of having global standards because an award might be enforced in one place or annulled in another. But there are also regional differences that I think we do have to take into account. And I do see this also, often when I've got maybe a lawyer in the firm who wants to get appointed in a case in the Nordics, and the parties are all from the Nordics, and the arbitrators are all from the Nordics, and any enforcement will be in the Nordics. And they say to me, oh, well, that issue here, don't worry about it. It's accepted here. The courts accept this or that here, which I say, well, that might be a problem in the United States. That might not pass. And they say, this has nothing to do with the United States. So we do have to recognize, and it's one of the beauties of arbitration, is that it's flexible. It is an alternative to the court system. And if the parties are happy with it, and everyone who's involved is happy with it, and there's nothing, there's disclosure, then we do have to recognize that it's not always the same for everyone. My issue about counsel having lunch with arbitrators, if everybody is involved, is from the Paris Arbitration community and thinks that's kind of standard practice and nobody's bothered by it, then who am I to say, no, you can't do that because for the system it doesn't look right. So I would just take everything that we say with just a grain of salt, right? I think there are global tendencies, but arbitration does have local specificities, and as long as we keep at least a minimum standard, we're okay. So I don't want to sound like we're too kind of high and mighty up here saying this is the only way to do things in a complicated world.
Thank you so much. But I think one of the common comments that we've heard is, I think Eduardo, you said it 3 times, the disclosure, and Patricia, you stressed that it was each and everyone's personal responsibility, and I think that's sort of what we should take away from this. Thank you so much. Thank you everyone for attending. Thank you for people online, and I hope you can stay for a drink before all the other drinks.